Hello, everyone. Thank you for joining. We're just going to wait a few seconds just so everyone can join live before getting started. So thank you very much. We'll be with you any minute now. Lovely. Okay. Well, thank you to Alyssa and Jonathan for joining me today. And hello, everyone who is joining. Welcome to Law 2021 Online, Family Law Shape the Debate, sponsored by Our Family Wizard with me, James Evans, Alyssa DaCosta-Waldman, and Jonathan Walker-Kane. In this live session, you can put your questions to Alyssa and Jonathan and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within the next few days, so please do keep an eye out for this. As I said, my name is James Evans. I'm a UK representative and professional liaison for Our Family Wizard. My role includes educating judges, barristers, solicitors, mediators, mental health practitioners, and all other types of family law professionals about the online tools that can be utilised to benefit and monitor parental communication in high conflict cases. Before lockdown, I travelled the country attending family law conferences, workshops, and seminars every year. I also spent 4 years as a teacher before joining Our Family Wizard. For those of you who don't know, Our Family Wizard offers divorced or separated parents a collection of web and mobile application-based tools to easily schedule parental responsibility, share important family information, manage expenses, and create an accurate, clear record of co-parenting communication. Working with parents on Our Family Wizard, family law and mental health professionals can leverage its tools to oversee communication and facilitate successful parenting through family separation and divorce. Our Family Wizard is recommended regularly by family law and mental health professionals and courts all across the UK, throughout the US and Canada, as well as in Australia and New Zealand. The first speaker I'd like to introduce you today is to Alyssa DaCosta-Waldman. Alyssa is a practicing barrister at New Court Chambers in London. She specialises in financial remedy cases and is also an expert in cohabitation claims. She's a regular speaker on legal topics and an author. During her career, Alyssa has contributed to Blackstone Civil Practice, co-authored Family and Matrimonial Law, solely authorised Everything You Wanted to Know About Practicing Family Law in 2004, and last year contributed the chapter on Trust Law to Resolution's Cohabitation book. Alyssa encourages and practices non-court dispute resolution methods as an experienced mediator, collaborative lawyer, and family law finance arbitrator. As part of Law 2021 Online, Alyssa's sessions include dealing with economic abuse in financial remedy cases and preparing and running international and domestic relocation cases. Our other speaker today is Jonathan Walker-Kane. Jonathan Walker-Kane is a family law practitioner who specialises in matrimonial finance, Talata claims arising out of cohabitation relationships, and claims brought under the Inheritance Provision for Family and Dependents Act of 1975. His pedigree extends to cases of considerable complexity, some of which are reported. He appeared in the case of Caudle versus Caudle at first instance and up to the Court of Appeal, where the key issue was the division of the proceeds of sale of a former matrimonial home in a volatile market and the court's discretion when hearing an appeal. He also appeared in Frere versus Frere, an Inheritance Act case on appeal. Jonathan is an experienced barrister known for his distinctive court style and sensitive manner with clients. As part of Law 2021 Online, Jonathan's sessions included The War of the Roses, an eponymous case of Rose versus Rose, it's considered and conduct unbecoming, and the proverbial penny drops landing on both sides. Let's talk about pensions. So to kick off, we will start addressing some of the pre-submitted questions that we have been receiving from you. And the first of those is coming to you, Alyssa. Alyssa, is there really hope of relocation cases settling?
Yes, but before I deal with that at length, can I just alert everybody that this morning, Mostyn J has released a new set of Children Act orders as of today. And if anyone wants to get hold of those, it's www.judiciary.uk/announcements/message-from-Mostyn-recommended-amendments-to standard-orders /. So just
there's a shortcut, Alyssa. There's a shortcut. You just go to Google and put in Mighty Mostyn and it comes up.
Oh, wow. Well, I don't know about that. But anyway, I just think it's appropriate that if we're having talks today about children and money and all of that, it's appropriate that we highlight to everyone watching that there's the new Children Act orders out there today. So done that, let's move on to my question about relocation cases. Now, usually you look at these cases and you think, well, they're binary, aren't they? Either you get to go or you don't, because if you can't agree it, you wouldn't have to start instituting court proceedings. But I'm happy to be able to report, having done, it seems, a vast number of relocation cases during lockdown, that people are, I think, much more conciliatory, apart from the one that I did that lasted 3 days in Wigan and went to appeal, and I won all of it. So there are people that aren't conciliatory, but where people are being reasonably conciliatory and where the parents consider themselves as parents rather than as warring former either cohabitants or spouses, whatever, if they put themselves back into their proper role as parents, then both of them will want to do what's best for the children or child. So it is possible, not easy, but it is certainly possible to settle relocation cases. And one thing that I would mention in that regard is child inclusive mediation. I don't think there is sufficient use made at the moment of child inclusive mediation. And I think where it is used and the child or the children have a conversation with the mediator, and then the mediator separately talks to the parents with what the mediator is allowed to impart to the parents from the children, parents often get quite a shock and it changes what they had planned to do. It just switches them from thinking about either getting at the other party or being very selfish and thinking about themselves to think, oh, this isn't good for the kids. So child inclusive mediation, I think, is very important and a very important factor in enabling certain relocation cases to settle.
Fantastic. Thank you so much, Alyssa. Jonathan, next question for you. Do costs always follow if conduct is pleaded and either your case is successful or you successfully defend?
Well, it's a tricky one. There are rules about costs in financial remedy cases, and the presumption is that there will be no order for costs. But in the lecture, if one looks at the case of Mr. Justice Robinson, sorry, not Mr. Justice Robinson, His Honour Judge Robinson, he talks at some length about costs, and I quoted what he has to say. In essence, it would appear to be this, really, that a conduct case should be properly litigated, and if in fact you follow the guidance of Mr. Justice Moore in relation of how that should be done, then that will incline towards perhaps a costs order if in actual fact you get home and it can be shown that the other side have behaved in a manner that is unbecoming, conduct that is so great that it has to be taken account of. The problem very often is that conduct cases are not properly pleaded. It's all a bit fudged, and there's no conclusive conclusion to it. The determination is nebulous, and if the determination is nebulous, then a costs order is unlikely to follow. But then this, and I think that this is very often forgotten, and to an extent Robinson doesn't talk about this, but it's clearly a factor. If it's a financial remedies case, you're talking about a costs order, then you have to remember that you've got party A and B, or husband and wife, but let's just call it A and B. And if A is required to pay B's costs, and they're significant, so say 25,000, so A pays to B 25,000, which makes A poorer and B richer. And the problem is, if it's a needs case, so actually, if it's a needs case, it will probably be unlikely that you would get an order for costs. But if you did, in the circumstances of a needs case, then all you've done is make one side poorer and the other side richer. And that has to be taken account of in the schedule of assets if you're looking at the capital disposition. So in actual fact, whether you get a costs order or not is not just a question of winner takes all. It's a question of balancing factors. How well was the case litigated? Was it appropriate? Because actually, sometimes, of course, you get a finding of conduct, and I don't mean litigation conduct, but you get a finding that conduct does impact upon the case. They're few and far between. But in fact, ultimately, that finding, although it has some impact on the case, is not sufficient to move the barometer towards the party who succeeded. So I think that advancing conduct cases have got to be carefully reflected, because in any event, very often, they cost more to litigate than what you actually get if you're successful. And even if you get a costs order, if the judge does it properly, he'll look at the effect on the parties in the round. Of course, if you're talking about a £3 or £4 million case where needs is not the problem, then likely you'll get a good and effective costs order. But if you're that rich, does it matter?
Can I just chip in on a couple of points?
Of course.
And I'm relating this to my economic abuse talk, because one aspect of conduct, I think, is economic abuse. Very difficult to prove unless, you know, there is a very expensive forensic exercise. But I'm wondering, and I'm just sort of posing the question, that perhaps once the new domestic abuse bill, which is currently going through Parliament and is in its final stages, once that becomes law, I wonder whether economic abuse will be raised more often as conduct in financial remedy proceedings, so that although judges don't like conduct, they may be forced to deal with it more frequently. And on that basis, if it is a conduct case and it is an economic abuse case, very often the economic abuse is the economically stronger partner trying to hide a lot of the assets, in which case a costs order is unlikely. You know, it punishes the person who's failed to disclose, the economic abuser, which I think is appropriate. And it's unlikely, if they're not disclosing a vast amount of assets, to have little effect, but it sends a message. And I think we might see more of that.
Wonderful. Thank you for that insight, Alyssa. The next question is for you as well, Alyssa. Isn't it the case that the courts always side with the mother if she wants to relocate?
No, they don't. No. This was a popular view, I think, many years ago, when I think, you know, more mothers just happened to be more successful. But there is nothing, there's no case law, there is no judicial practice that says, oh, yes, if the children are with the mother, then mother gets what she wants, mother gets to relocate if it's her application. That is not the case at all. The one guiding principle through every single relocation case, regardless of the type of relocation it is what is in the best interest of the child. That's the one guiding principle. Everything else is secondary. So it's not about the parents. I mean, obviously, there will be those cases, for example, where somebody needs, you know, someone is an immigrant in this jurisdiction and wants to relocate internationally to go home to have a support network, or the partner cases where there's a new partner and the new partner is the one who wants to relocate. But even in those cases, it's not a foregone conclusion. So
does that mean that a domestic relocation would be easier than an international one?
It depends. That's a good question, because it really does depend. It depends on the distance. It depends on the children. It depends on the relationship between the parents. It depends on resources, because there may be international cases that actually work a lot easier because of how the parties can communicate with each other, how they can arrange travel and contact to the non-resident parent. And yet there may be domestic cases where the arrangements can be more difficult. You know, if you've got one parent living in London, perhaps, and one parent living in Lancashire, and there aren't the resources to enable the costs of travel, that can create a lot of difficulty. The one great thing that this pandemic has taught us is this stuff.
Sure.
That you can have not direct face-to-face, but you can have meetings, you can see people in real time. And I think that has been wonderful for parents and grandchildren who are not in dispute, but how much better to be able to make use of something like this when there is a dispute. But no, I don't think one, you know, an internal or an external relocation, one isn't easier than the other because you've got so many variables to consider in each case, and each case is different.
Of course.
Alyssa, can I just ask you this? You mentioned that perhaps children might meet a mediator.
Yeah.
And discuss how they felt. There's always been a reluctance to bring children to court, even children of 12 or 13. And I did a case about a child who wished to go with his mother to Australia, and the judge refused to see him. She made an order that he couldn't go to Australia, and he upped sticks and left his father and just went and slept on the sofas of friends. It occurred to me, however, that if we had Zoom, if we had Teams, could a court not speak to children through this medium? So they're not required to come to the court building, but a judge could speak to a child, even in the presence of the parents, but in fact the parent's face is not visible to the child. I mean, is this not something that we should be exploring?
Well, perhaps we should. I mean, certainly now that we are, I would have some reservations about the child speaking to the judge with the parents present, because I think that could scupper the child being able to open up in the same way that they open up to a child inclusive mediator and the parents are not present. And there are strict rules about confidentiality. And if the child says to the child inclusive mediator, I don't want you to tell my parents that, I'm telling you, but I don't want you to pass it on, then it is absolutely the mediator's obligation not to pass that on. And I do remember a few years ago, I was involved in a case where children wanted to speak to the judge, and the judge invited them in and saw them in his room. And there was what one might call a responsible adult, but that was not either of the parents. And I think in many of the cases we deal with, we would certainly dispute whether our clients were responsible adults. But yes, I think it might be something that we ought to reconsider bringing back. It was happening for a while, many years ago.
And then stopped.
And it stopped. And I think perhaps there was a view that, you know, it wasn't good for the children. But I think the voice of the child is very important in cases, particularly where they are old enough to have a pretty firm opinion. They are old enough to vote with their feet, which is always a danger, as in your case. And that, you know, voting with their feet, having not been given the voice, can actually have a very dangerous and serious impact. So I agree with you. We perhaps ought to be promoting that.
And in response to that, we've had a live question from an attendee who's asked about domestic relocations. Are domestic relocations effectively lost if the parent with care of the children has already moved, you know, a new home, a new school, new job?
Oh, well, I mean, again, it depends. It depends where, how far was there communication between both parents? You know, not every case is a sort of relocation or a potential abduction. Often parents will be able to discuss and talk about better schools. But if it wasn't, then it might be a sort of internal kind of abduction case. And it may well be that that's the point at which, you know, somebody's looking at prohibited steps orders. And then the relocation.
And
Or
soon
even-
they'll be able to run off to Scotland, and Scotland will be a different place, a different
Exactly.
country.
Well, it may be that if Scotland is a different country, then we're talking about Scotland could be an international relocation.
International, yes.
It
yes.
could be. It could be.
I think that we might need a whole other hour to discuss what the
It is. Yeah.
Yes.
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 So, Jonathan, next question for you: are the decisions of
Yes.
Judge Richard Robinson binding?
Well, there's some interesting articles about this, and I think there's another question that someone submitted about His Honour Judge Hess. So in a way, I'm being asked to deal with this twice, but I can just refer the later question to this answer. The answer to it is no, and one article I think started with, although this is a decision of His Honour Judge Hess in Swindon, as if Swindon was an indictment.
It is.
No, they're not binding as such. They're not even as informative as we would say the decision of a High Court judge is. But there is no doubt in my mind, given what has happened since the decision of W&H and the decision in the other two cases, that there has been Judicial Studies Board training on this issue of pensions. And while they're not binding, I suspect it's a brave representative that goes into court now and says, but you're not bound by this. Because I think the district judges and indeed the circuit judges who are dealing with these financial remedy cases are of the view that it is certainly more than authoritative. And the thing that one has to remember is that the Pensions Advisory Group is much quoted, and what effectively these cases have done is to give a significant seal of approval to that report. Oddly enough, I was to represent the husband in W&H, and then he determined to be a litigant in person, likely because he discovered how expensive I was going to be. The odd thing is that he wasn't apparently disappointed with the result. I was told by the solicitor whom he was taking, what do we call advice when you go in for just a parcel of advice?
Unbundling.
Unbundle, yeah,
Unbundling.
yes. But I don't think the decision would have been any different even if he'd been represented. And I remind myself, therefore, of Caudle, where I was given a trouncing by the husband who was in person, Sidney Caudle. And it was clear that no matter what I'd said in Caudle, they were going to change the law when it came to looking at appeals from district judges. And actually, subsequently, I spoke with another barrister some years afterwards who said, we had been listed in another case about a fortnight before you, and we settled. But in advance of that hearing, we'd been sent specific questions by the Court of Appeal to answer in relation to the discretion for appeals. And indeed, we were sent those, but not till about a fortnight, 10 days before. So it was clear that they were going to use a specimen case, and we just happened to fall, actually, I thought, unlucky, because I was ill-equipped, really, to deal with that case on the day. It's 20-odd years ago. And indeed, although I think they would have ignored me, it would have been possible on the basis of the rules to point out to them that what they were going to do wasn't permissible. But in fact, they did do it, and then the rules were changed. I think all they would have done would have been to give a judgment saying, although the rules have got to be changed, this is what we propose. And as a consequence, the rules will be changed. I've gone off piste a wee bit here, but I think what I'm indicating is that it doesn't matter that these were county court decisions. They're here now, and we live with them. I suspect somebody will challenge, for reasons I'll come to perhaps later on, as to whether or not you can find a thin end of a wedge to drive into the decision. But I'll leave that for later.
Certainly. Thank you. The next question is one I'm going to pose to you both. I think we've touched on economic abuse in certain situations. When is the best time to issue a financial remedy application in an economic abuse case?
I would say ASAP.
Mm-hmm.
ASAP, absolutely. And, be fairly robust. Very often with financial remedy cases, what solicitors will do is they will attempt voluntary disclosure. But, those cases, they're the ones where you end up with a file that is sort of this much of correspondence and disclosure, where you've tried, but so much is missing. And I think if you are aware that somebody is or is likely to be an economic abuser, then I would say ASAP. Get it done as soon as possible. And you write that marvellous letter with that great line, we're going to issue, this is not to be taken as a hostile step.
Yeah, but equally, and I've got a case going on at the moment where somebody came to see me 3 years ago, and I said to them, you need to move on this now, but actually made noises to their partner, their spouse, that they were thinking that the marriage was over, but then didn't act speedily, went back and tried some reconciliation, etc. Of course, it didn't work, and now we're in the midst of proceedings. But in that intervening 3 years, what's happened is the other party has been in a position to start to siphon off and to build a case which clearly has undisclosed assets.
Yeah.
So I think that if you get someone come to see you about the future, I think you have to warn them that in many circumstances, particularly if they're self-employed, if they've got a business where it will be possible, then you need to move it. Slightly anecdotally, and I have to say that the judge in the case is refusing to allow me to tell me about what happened in a case I did in Newcastle years ago in front of Mr. Justice Cobb. And that is something that seems to be happening a lot these days, and I suspect there must be something on the internet about it. And it's the use of family loans, which are evidenced in writing, as a conduit for money that actually really belongs to the party. So what they've done is they've stacked money away with a relative, or they've sold shares.
Yeah.
So the relative's holding this money, but they're very careful in how they do that. But they want to access it. So what they do is they get loans from the family member.
Which then the court's going to say, oh, it's a soft loan, we're not going to worry about that.
Well, save that if you tighten it up, you can sometimes persuade them.
Yes, you can.
But in any event, yes, it's a means. And I think you've got to look very carefully at family loans, particularly if you've got financial abuse, because it can be just a conduit for money. I
think you're right. It's a way of siphoning off. But for the poorer party, who may be having to rely on their family loans to get them through a financial remedy case because of the economic abuse of the other one, then I would say that it's really irritating when there is a great disparity in the finances and you're acting for the person who's having to use family loans, and all the other side and the judge say, oh, well, it's soft, it's family. And I would urge two things. One, to make sure that any family loans are put in writing in a proper formal loan agreement to give it some weight. But also, I would advise that if anybody is in receipt of family loans to get them through the proceedings, that the solicitors are paid directly by the family.
Direct, yes.
Because if the money goes, from the family to the client to the solicitor, it's much more likely to be regarded as soft. Whereas if it goes from the family straight to the solicitor, it's much more likely to be regarded as something that has to be repaid. But
still with the loan agreement.
Oh, for sure. Yeah, absolutely, for sure.
So like a school fees order. The payment to the solicitor is payment to me. Yes. Yeah,
that's right. But belt and braces, loan agreement, and it's paid directly to the solicitor. So definitely that form of sort of belt and braces. Yeah.
And of course, Alyssa, there are tools that parents can use to help them track their expense.
Yes, they can. Absolutely.
Well, I thought it was an appropriate time. the next question has come live again, so it's in response to a previous conversation we were having about pensions. So you stated that pension cases decided close to retirement age will be based on pension income rather than pension capital. Does the new partner's ordinary income and pension income play a role in equalisation?
Well, certainly the pension income does, to include state pension. And I was in front of a recently appointed judge in a place I won't name because they sit alone and therefore they would be identifiable, who talked about substituted national insurance for a wife, which has been gone for an awful long time. And everybody has to remember now that state pensions have to factor into a pension report if you have to have one. But even if you don't have a pension report, you must have a printout, and it's so easy now
you can
from
do
the
it
department
yourself.
telling you.
You can do it,
yes,
yes. On the internet. It's very easy.
Yeah. And I think that that income is important and necessary. That I suspect that earned income isn't going to be factored in an argument of equality, but it could, I suppose, Alyssa, be factored in a needs case. So
potentially, but I think we're losing sight of the whole purpose of pensions in retirement. I mean, I've always had a particular rule of thumb that if the parties are the right side of 50, you're looking at equalisation of pension provision. And if they're the wrong side of 50 and therefore closer to retirement, what you're looking at, and that's why we need reports, we need the POD, as you properly put it, we're looking at equalisation of income in retirement. And if we're talking about income in retirement, then we're talking about two elements. We're talking about state and private pensions, because if it's in retirement, I think it kind of implies that there isn't earned income. And if there is, then it raises all sorts of other horrible issues like tax. You know, how many times?
Well, if a party determines they're going to work beyond retirement age, I find it a harsh court that decides to trawl in that income in an application for periodic payments. Yeah. And frankly, if a party then said, well, if I'm going to be subject at 70 years of age, because I choose to work, to a further periodical payments order as a consequence of that, I'm not going to work. And how could a court be critical of that? Because retirement age at worst 67, perhaps going to go up again, but can somebody be really criticised if they elect post-retirement years not to work if they're going to be subject to the order?
I agree with you. Yeah.
Nice to see that we agree. I think that's a perfectly way of summing up. So circling background from pensions back to abuse. What if the abuser won't cooperate with a court order? You know, for example, to sell the FMH.
Oh, to sign documents. Well, there's the wonderful, I think it's section 39 of the Senior Courts Act. And although that refers to the High Court signing documents, those of us that have had this wretched experience of having to go to court and get such an order, county court judges can do it. Any judge on the appropriate application will sign conveyancing documents if a party is being obstructive, and they're very willing to do it.
Excellent.
And
I think the most difficult thing is actually when you get an occupant of the matrimonial home who's to sell and doesn't want to. That's, I think, the most difficult, because if you've got an unwilling seller in the house, they can thwart, say. And what the courts require very often to persuade itself that somebody is an obstructive vendor is costly. And the unwillingness of the court to make costs orders in those circumstances, I find infuriating at times.
But before you even get to that point, you know, I've had a case last week. Well, if we settled it miraculously, but I drafted that order because my client, the husband, is the sole owner of the former matrimonial home, but the wife and children are living in it. And the wife is the reluctant seller, even though she's not the official vendor. So I put in loads and loads of undertakings that she had to sign to ensure that she didn't obstruct the sale, to ensure that she kept the property in good order, didn't do any sort of destruction of it, that she's going to leave it in a clean condition on completion, and lots of undertakings that her solicitor happily got her to sign, so that she would be in breach if she did anything that could be considered obstructive of the sale.
Perfect.
Yeah, I think you need to preempt a lot of these things.
Sure.
Do you think, Alyssa, though, that it falls into financial abuse? I'll give you an example. At the moment, I've got a case where the wife will not sell. She's now refused to pay the mortgage. She was paying half. The husband was paying half. She's in residence. She has a son in there who's mature. She won't move out. She won't sell. She won't pay her half of the mortgage. We've got the stamp duty holiday. It would sell for more at the moment, and there's a clear valuation saying sell during the holiday and you'll get more. She won't do any of those things. There are other reasons why we're going to be a while before we get to a final hearing. Do you think at a final hearing you could say that that's financial abuse, to continue to live where you refuse to pay the mortgage, you refuse to sell, and you do so against a background of seeing the property worth less?
I think there is a fine line between what could be regarded as a campaign of economic abuse to control another person throughout the relationship, and behaviour that is designed to delay or otherwise put pressure on the opposing party within the litigation. I wouldn't necessarily call what you're describing economic abuse. I mean, it could be construed that way, but I think the motivation is a bit different. If it's a case where previously that particular party had not engaged in what you might call economic abuse, I think in these circumstances, it may be that they are so hurt by the breakdown of the relationship, they're trying to control that part of it. You know, I think we have to look at the motivations of people, and also, you know, context, history of the relationship and those sorts of things before we give everything the label of economic abuse.
Well, I'll just add one thing, however, is this. I'm not going to pay the mortgage and I'm not going to sell unless you agree to this. So it's actually an effort to extort. That must be a form of abuse, because it's a form of blackmail.
You've reminded me of a very famous case about a Jewish divorce back in 1969, where in fact that behaviour is exactly what the Court of Appeal did in a case called Brett. Because in Brett, the Jewish husband refused to give his wife a get. So the Court of Appeal put an extra sum of money available if he did. So there was an incentive. So, you know,
now why did they think he would be interested in that?
You know, there's always a question. It's sort of, you know, whether we call someone a terrorist or a freedom fighter, whether we call something a bribe, pressure, or an incentive. And right. I think much of what we call it depends on which side we're on in the case.
Well, like Tevye says, aye. Right.
I'm sure putting a label on each of those categories doesn't make it any easier for anyone.
No.
Particularly people who are trying to put everything into a sort of make a final decision.
Yeah.
So I guess that leads nicely on to the next question, I suppose. Is this therefore the end of what is so-called ring fencing? I know that may be more in regards to pensions, but where does that leave us with ring fencing?
Well, that's what's interesting about, and I'll just find the name of the case. Because, oh dear, just hold on. I think I've. Well, it's it's His Honour Judge Robinson's case. Yeah. It's the third on my list, and I just momentarily can't find the full citation. And I won't waste time.
KM versus TV.
It's yes, that's it. I think it is anyway. That's quite an interesting case, and it took some teasing out. I had to really pore over that, because in effect, what he says is that needs is the first and primary factor, But if the judge has considered needs and feels that his order will meet the needs of the parties, if there is ring fencing, then that is acceptable. You could, and the problem that I had with it was, do you consider needs first and see the extent to which they can be fulfilled before you even factor in ring fencing? Or do you look at the effects and consequences of your order in the round immediately? And I just had to conclude in the end that the needs factor has to be considered first. And so really there would be two questions. The person who wants ring fencing, what would the consequences and effects of that be on income in the future? And if ring fencing isn't applied, then what is the consequence of that economically, income-wise? And if with ring fencing it still meets the party's needs, then you could consider it, looking at the point in time of accrual, etc. Yeah. But I have to say that it took me a long time. I'm not the sharpest knife in the drawer, I accept that. And it did take me a long time to actually work out just what was being said. And there's a marvellous phrase, although I got into trouble for using it in court the other day, where he says you cannot compare capital assets and pensions because it's apples and pears. And then I love this. But you can consider the fruits of the orchard. If you remember,
fantastic.
The fruits of the orchard could be different. And I thought, well, that's a gloss. Yes, that's a gloss.
You could compare fruits of the orchard. Well, you do have pears in an orchard and you do have apples. So what the hell is he talking about? And it's interesting. Yes. I had exactly that argument in the case last week where a judge said to me, but you're comparing apples and pears. And I said, yes, because you can.
Yes, in the same orchard.
Yeah, they are in the same orchard. We're okay.
Yes.
Oh. Well, I think it's a very apt metaphor, if a metaphor at all. Yeah. I'm going to ask you now, and I don't know, you might not enjoy this as much. We discussed magistrates before we came on. Can magistrates hear relocation cases? Should they? Can they?
Well, yes, they can. Whether it is appropriate, I think, depends on the type of relocation case it is. And if it is a case of complexity and with international elements, I would say absolutely not. But if it's a simple domestic relocation with no particular elements of complexity, there's no reason why regular magistrates who deal with children cases all the time, and most of them, I have to say, I mean, I have in a past life called them the wooden tops generally, but many of them actually very good. I did my 3-day in Wigan relocation case recently, which I was very successful, but on appeal, the mother, I acted for the father, the mother was complaining that a deputy district judge, who was only a deputy because he'd been pulled out of retirement to hear this case, but he was a man of huge judicial experience, she was saying he wasn't competent. And interestingly, it was the designated family judge in the area, who was a circuit judge, who designated him to hear the case because of his experience. But this was a mother who didn't like the result and therefore was clutching at straws. But yes, any level of judiciary can hear any relocation case, but obviously you've got to be sensible and help the court in getting the right level of judge for the particular case that you're dealing with.
I struggle with magistrates dealing with anything that's in the slightest complex. I've just lost you a second, but I think it's just a momentary thing. Just hold on.
Yeah, you're all good, Jonathan.
We've got you, Jonathan. You're still with us.
Yes, it was momentary. Yes, it was momentary. I say that, but in fact, the problem is that with a complex case, you're not asking if the magistrates are competent. Unfortunately, what you're asking is the legal advisor competent?
Yes,
because the legal advisor's role, and I worry about that, because the legal advisor is not supposed to make the decision. But I've done cases. I don't go into magistrates' courts now for reasons I could tell you, and if we have time, it's quite funny. But I do worry about magistrates in complex cases. And the other thing is this: I also worry that so many of them, although less so now, but certainly when I first came to the bar, they're always grandparents. And I think they consider a case.
I'm a grandparent.
Yes, I realise that. But I think that they're infected by their feelings of being grandparents and about the removal of children and how it would impact upon them. And I don't think they've necessarily got the skill to distance themselves from that. I know that's awfully parochial, but I really do question very often their ability to be entirely objective in a case. And somebody asked you a question about, is the mother likely to be more successful? I think in magistrates' courts, you do have a problem in persuading some magistrates that the woman isn't de facto the primary carer. And I think you have to work hard in the magistrates' court in that way. But I'm not a lover of magistrates, and I am going to say this. I felt that I think when Potter was the president, I went to a lecture that he gave about how they were going to reshape the family court. Remember somebody saying to him in a hostile way, is this not just a way of doing justice on the cheap by having magistrates' powers increased? And the odd thing is, it might be on the cheap for the government, but invariably it's more expensive for the client, because it always takes longer.
Well, it
a
takes
one-day case in front of a circuit judge.
Yeah, it takes longer, and ultimately you can start in the magistrates, you can have many hearings, but ultimately if things aren't working, you've got to go up a level.
You go up.
Exactly. Yes. So in many respects, you may well be better off starting off at district judge level rather than magistrates.
Well, the problem is that gatekeeper thing, but I think we're digressing from the question.
Yeah,
I apologise.
Yeah, but I think, but you're right. You're right about legal advisors, and you need decent legal advisors, and many of them, unfortunately, fall short.
Yeah.
Well, thank you for your thoughts on that both. Jonathan, we're going to come to you next for a specific case, the case of W versus H with His Honour Judge Hess. We're wondering if you can talk us through that case and whether that's considered binding as well.
Well, I think that I was saying essentially it was when I mentioned it before.
Yes.
And what I was suggesting also is that he's made the PAG report binding. I love this Poday, as somebody pronounced it the other day.
Oh,
Poday. So I thought that sounds like the title of a song, not a very good song. There's no doubt that it's binding. I mean, it's a very well-crafted judgment. He used to lecture for Jordans and used to do procedure, etc. I think he started life as a district judge. I can't remember, but I think he did and was elevated during Butler Slosser's period. But it's authoritative, and I suspect that most judges are going to be of the view that they're bound by it. And I think you have to really know the ins and outs of it. Because he's so good on offsetting, and it's all broken down. In fact, Alyssa and I used to joke about this before, that we used to talk about having the television on and stickers and reading a brief and just putting a few stickers in and making sure that your client thought you'd read the papers. But we weren't being serious, I hate to say.
Certainly not.
But it seemed to me that this was at Kensington Town Hall, and we were just aping.
Oh, long time ago.
I think that it's right to say that, yes, that you could cut and paste large sections of his judgment into submissions because they're so succinctly put. And there are 3 headings. You've got all that you need. Title of the case, facts. Every case turns on its own facts, but needs as a principle doesn't turn on its own facts. Needs is the starting point, and the facts, which might change, apply. But he then talks to you about the 3 things, and cut and paste, and I'm not saying you're home and dry, but I think if you have, well, I'm going to do something in Lincoln where a deputy district judge at an FDR just said, well, the wife retains all pensions, premarital accrual, and that's the end of it, and doesn't in fact meet the husband's needs at all. He's an immigrant who's not even entitled to state benefits.
Yeah.
Well, it didn't settle, and it's going to go to final hearing.
Yeah.
Excellent.
No, I think W&H, I think it's kind of landmark, even though it's not Supreme Court, it's not Court of Appeal, it's an ordinary circuit judge, except what you have to understand is Hess is no ordinary circuit judge. Hess was on the committee, the pensions advisory group.
He was the joint chair.
Exactly.
He was the joint chair.
Exactly.
Yes.
So he was responsible for putting that 176-page report together. He probably knows it absolutely off by heart. And I agree totally with Jonathan where he says that is the most beautifully crafted judgment, because it is. He poses questions, he puts what PAG says, he puts the facts of the case, and he does it so beautifully. It's a long read, but it's a good read, and it gives you so many guiding principles for pensions that, it's my go-to case.
Excellent. Excellent. We're getting there to the end of our time. We've got a few minutes left, and we're gonna pose you one more question, possibly two, depending on time. And Alyssa, this is one for you. It's more of an example case here. If my client has a former partner with a new baby from her new partner, and the new partner wants to relocate with the former partner's child with your client, is a hearing just a formality, or isn't it likely that the former partner will be allowed to relocate anyway?
No, it's interesting. There's lots of issues here. So mother has new partner. New partner's obviously from a different international jurisdiction. She's had a new baby with the new partner. So she's got two children because she's then got the child with my client, if I get the question correctly. So my client's child with her is the older child. She's got the new baby. What's going to happen? You've got all these issues. Is she going to be allowed to go and live in, let's say, France with partner and new baby? What if it's somewhere further? What if it's America? What if it's Australia? And what about the older child? Does the older child have any issues? And I'm thinking, it's not a foregone conclusion that this mother, simply because she's got a new baby with the new partner, will be allowed to relocate wherever. It depends. It depends on the distance. It depends on the relationships. And the child who is the subject of the relocation case, the older child, if that child has educational issues, maybe special needs, then that could be a case where mum is not allowed to relocate, because that child's needs need to be dealt with here. Mm-hmm. Mm-hmm. So, what one has to look at, there are no obvious answers to any of these cases. And I said earlier, every case turns on its own facts because there are so many variables in each case. And you can see, I've already mentioned a few that there could be in that rather complicated question.
Yes.
Well, ultimately, though, what you're suggesting, Alyssa, is that the facts never trump the welfare of the child.
Well,
again, like needs in finance.
And that's what I said
welfare top. Then you look at yeah.
It's always the best interest of the subject child.
Mm-hmm. Mm-hmm.
Yeah. That's it.
Excellent. We have 2 minutes left. I'm going to try and squeeze one more final question in for you, hopefully, to just give a quick answer to. What, in both of your opinions, what is the most important factor or factors that are really important for the courts to consider in a relocation case in 30 seconds each?
Best interest of the child and links to the family that will be left behind. Maintaining links to that family.
Mm-hmm.
Well, on a slightly frivolous note, if frivolous is the right word, try to avoid telling everyone that you met on the internet.
I like that. That's a good one.
Very good. Lovely. Well, unfortunately, that is all we have time for today. Thank you very much to everyone listening for attending the Law 2021 online Family Law Shape the Debate, hosted by our family wizard. Thank you ever so much to our expert speakers, Alyssa DaCosta-Waldman and Jonathan Walker-Kane. Thank you both. I really have appreciated your time. Don't forget to join the Solicitors Group Law 2021 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned at the start, a recording of today's live Q&A will be sent out by email within the next few days. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you will also be able to find the online exhibition. The exhibition is open for anyone to visit, and if you've booked the entire event online, you can claim one free CPD webinar from the Webinar Learning Catalogue, which is worth £35. You can also visit our Family Wizards exhibitor booth for more information about Our Family Wizard. You're also very welcome to get in touch with me anytime if you have any questions. And Alyssa, who I know who's a big fan of us as well, has used us as well. So you can hear about it from her as well. And finally, you will be receiving feedback forms for the event. They'll be sent out when the event closes. And by completing this, you will receive that CPD certificate. Thank you again to Alyssa and Jonathan. Have a great day. And I look forward to catching up with both of you soon.
Thank you.
Thank you.
Thanks.